I'm Vicki Langford with Project 3810. We are a business incubator here in West OKC, and our mission is to help people become better bosses. Project Boss is our special op to accomplish our mission. Bosses have to manage the business from sales to operations to finances. Bosses need to develop their leadership styles and effectiveness in order to achieve results. And our boss members participate in peer coaching through Boss Board meetups and Boss Board Roundtable. We expose our bosses to subject matter experts and introduce them to key players to help them achieve their business goals. Hello, everyone. Today we are in our podcast studio. We just had our lunch edition of our Boss Board today. Have Ross Chafin with us he's an IP attorney, and I got Kyle in here again. Hey, Kyle.
I'm back again to get my marketing spin on this interesting conversation though about IP protection. Yeah,
it's going to be great. Ross, introduce yourself, please.
Yeah, I'm an intellectual property attorney. I help clients of all sizes, from billion-dollar companies to individual inventors, with patents and trademarks, and also the protection of those patents and trademarks. And then also, one thing that I think people don't think about a whole lot, especially early on in the process, is, well, what if my patents and trademarks that I want to get, or what if my products or my brand names that I want to use are subject to somebody else's rights, and how do I deal with that? So those are a lot of the issues that I help clients with, trying to sort through, especially when they've got again, cool products, cool ideas, and cool business strategies that they need help with. So
awesome. Well, thanks for being here. It's been a great lunch edition of our Boss Board, and we're going to dive into that thing. So tell us what is IP? Like, what are the categories of IP?
So intellectual property. Yeah, intellectual property. And, you hear that phrase and you think, well, it's something, it's property of the mind. And that's kind of true, as silly as that sounds. It's not all that different from a piece of property or a piece of land that you might have. It's got restrictions on who can use it, just like your property at your house might have restrictions on who can be there and who can operate. So in general, the categories of intellectual property that we're going to talk about today, and this is not exhaustive, but the most common ones are copyrights, which protect the way whether or not someone can take a creative work and copy it. Trademarks, which really are the brand association between a product or a service and the business owner, the person that's pushing that product or that service. Patents, which protect functionality or the ornamentation on a product. Generally, it's a article of manufacture, it's a apparatus, or it's a method of using it. And then trade secrets, which aren't as protectable in law. Like, there's not a trade secret registration that you get, but they are often really valuable to companies because those are. It can be a perpetual right, and sometimes the trade secret or the secret sauce can be something that matters a lot. So anyway, that's generally what intellectual property is.
That's awesome. I learned so much today too. So on the trademarks, or copyrights, let's talk about that first. And if you listen to our last podcast, we talked about product development,
right,
and we had our marketing perspective and in here on that.
It was marketing versus engineering versus accounting.
That's right.
Now we're bringing legal into it. I love it. At what point should we contact you?
Okay, so I think that one really, really important thing to think about when we're talking about those categories, we're talking about product development with engineers and with marketing folks. Those are really going to be the engines that drive the development of a product. And they're going to be the engines that drive the development of a brand identity. So when we're talking about trademark, the lawyer is really the party that comes in and cements that stuff and protects it, who gives it a little bit of a shield against other people, and then maybe a sword if you need it because somebody is doing something that they shouldn't. Getting a lawyer involved, it really depends on which type of intellectual property we're talking about. So in the case of a patent, there are really bad things that can happen if you have a product which might be patentable, and we'll talk about patents specifically later, but you don't go and you do and protect that invention. So if you have an invention, it's good to get the legal side involved right away.
Because there's a time frame, right?
Right. You have a certain amount of time from your first public disclosure where you have to file something or you lose it forever.
Right. And shorter than most people would think, that time frame.
Right. And it can, really the best practice, and what I would tell somebody, if you can help it, don't sell the product that you think is patentable. Don't show it to anybody outside your organization before you do something, or at least do an analysis to figure out whether the product is patentable. Now, you have about a year of grace period where in most circumstances you can still file your application, but that, again.
So if you have an invention, you almost need to treat it like a trade secret.
Right. Yeah. You need to treat it like a trade secret until you file something. Because once somebody else has knowledge of it, they can do a lot of stuff that can hurt your patent right.
And so with that, like to talk on trade secrets, then that's when you get the NDAs and so you might need legal to make sure you have a good NDA, like a non-disclosure agreement or something like that. And if you're talking to someone who might manufacture that for you or to get a prototype made or.
Yes. I think that non-disclosure agreements are important, and also processes to make sure that what you have is really a secret. But trademarks, which is what you asked about, so sorry about that. This is me.
Everything in this case is circular.
It is really related,
which is why understanding each aspect and understanding the nuances is so important, I think, for this discussion, because it can become overwhelming trying to figure out what to do in what order, depending on your actual approach to what you're doing, what you're trying to accomplish.
Gotcha.
So one of the things we talked about in the lunch today was how a lot of the things that apply to patents, which is what people think of, I think, immediately when they think of intellectual property, and how the rules apply to trademarks can be kind of opposite. And so let's talk about trademarks, because I think that trademarks in a lot of ways are the most important of the intellectual property categories when you're talking about a business generally rather than just a singular product.
And I agree with that statement 100%.
Yeah, the marketing
guy
side, of course,
says
we are. Yes, brand value and brand equity and the protections that you can place upon them are huge, because everything you ever do is to present a brand that your audience, your public, is going to connect with and have a high reputation for. So the ability to do that well and protect it where you can is essential.
Right.
From my take.
Yeah, I agree, and I think sometimes lawyers, because patents are a little bit more complicated, can look at patents as being the valuable piece. But if you have a good trademark, that is going to be the thing that people will associate with your product and with your brand and with the quality of that product and what it is. And so, when we're talking about trademarks generally, we're talking about the names like Nike or Coca-Cola or Apple. We spoke about a lot. And you immediately have something come to mind when you think about those brands. And so you can't just invent a trademark in your room and have something of value. You can do that with a invention.
Well, it's only valuable to you. It's not valuable to anyone else.
Right. And it's not valuable under the law. Because when do you come to your lawyer about trademarks? Well, really when you have a business plan that's solid, and sometimes it may even be preferable to wait until you've got some sort of market response to your brand.
Which is pretty deep in the process.
Right.
Well,
that's absolutely not at the beginning of the process.
The only thing I've seen is that people get hooked on their name right from the start. They don't take the time to just see if the name is available. You don't have to get the trademark right away, but you should kind of definitely search.
For sure.
You have to understand if you're going to have a problem
before you invest
with
in designing a logo and buying domain names and all that stuff.
Which are but pretty good indicators too, though, is if you can't get the domain name, that should be almost step one in the naming process, which is if I can't get the domain name, which means you're using common terms or a name that is already out in the universe.
Yep.
Then you already have to start adjusting that thought process.
Yeah, and I think that if you have a good name and you like that good name, you should know enough about your market and your competitors to have a good idea of whether or not it's going to be available. I think that, a lot of times, sure, there might be someone who you're not expecting who you don't know about and who's not really competing against you that has a trademark that's a problem. And that does happen in some percentage of the cases. But for the most part, picking a trademark, a part of that process is knowing your competitors and knowing what your market's going to look like. So you're not always going to be able to know with 100% whether or not everyone who sells something like what you want to sell uses different trademarks or not. I mean, you may run into a problem. But you should have at least done enough work to have a general idea to see whether or not you have trademark clearance, and then you can talk to a lawyer. You can get someone involved, and you can do Google searches. There are all sorts of techniques that are at the disposal of folks.
And we'll put some links in our notes on the podcast.
Now, real quick on a marketing note, the strongest key to building a good business when it comes to marketing is differentiation. It's setting yourself apart from the competition. So this is where that conversation starts, which is understanding who you're competing with and how you're going to set yourself apart from them. Your naming, your logo, and all the things that come with the brand elements that make up what a brand is needs to be different. It needs to be connected to the product or to the audience or to the industry, of course, but it also has to be very distinctly different from anyone you're competing with, not just on a legal level, but on a marketing level if you want to have a successful business.
I agree.
And that's exactly the same standard that will be applied legally, because trademarks really aren't about protecting a business owner. There's a little bit of that, but really all of the tests when somebody brings a case, of trademark infringement against someone. Really, all of the tests have to do with consumer appreciation of what that brand name means, and so the consumer's impression is going to be key here. Now, the best trademarks don't have anything to do with what the product is, and I know that sounds weird, but the best and strongest trademarks and the trademarks that become registrable at the U.S. Trademark Office the most easily are ones that are somewhat fanciful, but may have some sort of indication of quality despite that. So, if you think about, large consumer product brands that we talked about, I mean, everyone likes to mention Apple. Well, Apple doesn't have anything to do with computers or phones, and Apple is a fruit.
It's as untechnology as you can be.
Right.
It's organic.
It's pure.
Right. And we joke about that.
Right,
and we laugh about that.
Those are good design decisions.
But absolutely. So it gives this impression of, okay, it's sweet and it's wholesome and it's pure. And all of
an apple a day, right?
Right. And none of those things have anything to do
That's really good branding.
at all.
Gosh.
Right. It is. None of those things have anything to do at all with being a technology company.
Yeah.
Right. Except that they create an image in the mind of the consumer. Nike is an example that people will use too. Nike is a Greek goddess, and so that name sort of conjures an image, but it doesn't have anything to do directly with shoes or sports apparel. And so it's suggestive of something, but it's not descriptive. It's not, the world's best shoes, TM. That's not a very good that's not a very good trademark.
Yeah.
Whereas Nike could be a good trademark. And so I think that thinking about your brand, obviously you don't want these legal requirements to drive the ship, right? And I don't think you ever want legal or I don't think you ever want a legal department or a lawyer to be driving decisions about marketing.
I'll tell you, as a marketing professional, I do not.
You're right.
Absolutely do not want that to be the case.
And I can tell you as a lawyer that I absolutely do not want that to be the case, because I will do a very poor job because I've tried to brand myself and I'm not very good at it. But what I can
But it's also the same conversation as you shouldn't have just solely economic factors shouldn't be your driver, or just solely your competitors or what other people are doing shouldn't be your decision-making driver either. They're aspects of the whole conversation, but they're merely aspects of the whole conversation. And that conversation still continually goes back to differentiation.
Right.
Yeah. And when you get the different departments around the table, you should have those differing opinions so that you can come to a better decision overall.
That's the conversation that's necessary.
Right.
Yes.
Yeah.
And so the marketing people really are the folks that will know the question of, okay, this is a good trademark, or this is a good use of the mark, or this is a good way to, package the product. And then it's just the lawyer's job is to be that tool that will go and protect it, or will go and get clearance for the use of the marks.
It's not too dissimilar to engineers saying, if it's manufactured this way, it won't break, or it'll last a certain amount of time. It'll perform as
you need engineers to help the invention come alive and make the product ultimately function. So
right, totally agree. And so I would say that most people underestimate the value of trademarks because they aren't technical. There's an aspect to them that makes it seem more like it's a creative job rather than being one that is a technological job.
Yeah.
But in fact, the consumer's really they're gonna care about whether the thing that they're buying, whatever that doohickey is, they're gonna care whether it works or not.
Yes. Is your product or service meeting the expectations set by your marketing?
Right. Is it meaningful to me as a consumer, and am I getting the value for my money for it? And then if the answer is yes, then that trademark is going to have some value, or what we call it in our world is goodwill, associated with it that can really be incredibly important. And it's a lot more important many times than the little technical issue under the hood that makes it go. That you might have any number of technical things that make the product go, and if you don't segment yourself from your competition or from the market and make yourself obvious to a consumer, draw the connection between your product and yourself, then you're going to have a harder time getting that repeat business and that sort of thing.
So let's break really quick, because do the searching on your own. Use Google. Go to the Trademark website. They have ability for you to search trademarks. See if there's things in your industry space, because you can have the same name if you're not in the same market, right?
Yes, and the way we talk about that is if there's a likelihood of confusion. If an ordinary person is not going to look at a car.
Oh, use the one you guys were referring earlier, the WWF.
Yeah, well,
no one confuses Saving the Pandas with pro wrestling,
and that's a little tough because they did have.
But pro wrestling still lost that case.
Right. Yeah. I like to use, when I'm talking to people, I like to use Fox Collision Centers and Fox TV Network. No one's going to question whether or not Tucker Carlson's going to come out and buff your hood.
Or if you are if your business is based on geography, if you have a restaurant, if you have a shopping center, if you have something that's brick and mortar that's in a specific market or in an area of the country where someone who you might be confused with doesn't operate.
Exactly.
Where things that are products that can be shipped anywhere, or electronic items, or things on websites that are virtual, they could go worldwide. Then maybe someone's already in a market that you're not aware of, but they're using the same name and it's something that's easily confused, or not, because again, it depends on what the form of the item is, right? Nike water bottles would be different than Nike shoes, which would be different than something else that might have a similar name. Right,
and though you've also got to be cautious there, because I would argue, let's say Nike, let's imagine that Nike didn't make water bottles. If somebody shows up and they try to start making Nike water bottles, and Nike is essentially a sporting goods company.
Yeah, that was probably a bad example.
Well, but I think it's instructive. I think it's helpful because
we said earlier though, like Bob's Apple growing business isn't going to get sued by Apple.
Right. That's true. That's true. That if you're really just describing what you do, trademark works so that you have a right to just describe what you do in your name. Now those, like as we've discussed, those are pretty terrible names in general, unless you're really just you have no desire to expand outside of the Yukon area apple orchards.
It is one of the conversations I've had plenty of times with clients, potential clients, where they're like, this will be a great example. Don't feel sad, Vicki, but it's Project 3810 because it's at 3810 North Tulsa Avenue.
Right.
So it's
I'm not going to scale that around the world.
It's true. But
I could.
You have a building here, right?
I'd argue 3810 is a little bit better because, once you leave this place, if you did, I mean, it's a little bit fanciful. It's just four numbers. And so if you put that in Dallas, right, then it wouldn't have any meaning, and that's actually good for trademarks. It's as crazy as that sounds.
Oh, okay.
But if it was 5th Street,
Yeah, right.
It may be something more specific because whatever market you went into, if you weren't on Fifth Street, there could be some heartburn for you as an operator.
Isn't there a finance company that's like Fifth Third?
Probably.
Fifth Third Banking. Yeah.
Oh, awesome. So, okay, Trademark. I've come up with my name. I've done my searching. I haven't gotten any revenue yet. Should I come and get a trademark?
So until you use the mark in commerce, you actually can't register the mark. Now, you can file an application. My recommendation to people is generally that you shouldn't. You can if you're really certain that this is your mark. But, you can file the application and get it going. But really, you don't get any protection until you use the mark in commerce. And then I think equally as important, you can't keep your protection unless you continue to use your mark in commerce. In fact, if you have runaway success and you've got a incredibly powerful trademark and you've used it for 30 years and then you close up shop and you stop using it and you stop using it anywhere and you don't have a good excuse for why you've done it, somebody could show up 3 or 4 years later and start using the name and
capitalize on your goodwill.
Essentially they can. Now, you have to actually abandon the mark, and the standard for that is one of those legal it depends standards. So I'm not going to draw a bright line rule, but at the same time, the key to trademarks is you got to use it or you lose it, and you really got to use it in order to get it in the first place.
But continual use, you won't ever lose it if you are in continual use.
If you're in continual use, you'll never lose the common law right. There are some renewal fees you pay to the government because the government likes your money.
Of course.
But
unlike a patent that will run out on a time schedule.
Right. Where a patent has a specific time frame associated with it of 20 years, whereas a trademark, there are trademarks that were filed 100 years ago that are still in use.
We're going to run out of time today because this is a great topic, and I'm going to ask Ross to maybe do a part 2 and a part 3 or something. But let's just close out this 30-minute on trademarks. So sure. You mentioned in our lunch about the TM. So how does that work?
Okay, so you will see a lot of times a company use a brand name and then have a TM in superscript. That's just an indication that the company says, this is my trademark. And anyone can use that as long as they're holding that mark out as a trademark. The circle R is a symbol of registration. And so that indicates to someone, hey, this is a U.S. certified registered trademark. And you can't use that. It's false marking and subjects you to penalties if you use that without having the registration completed. Now, I've seen it. I've seen people make a mistake there before. Obviously, people make mistakes. But I've also seen people make mistakes, and then the trademark office finds that mistake during your registration attempt, and then they come down on you during the trademark application process.
Oh, no.
It's not something that should be done.
I've had those conversations with people who are starting a business, and they come to us for branding efforts, and they insist that well, where's the R? Like, well, have you filed for it? Yep. And the only way you get to convince them that they're not getting that R is you're going to pay a fine. The government's going to come and get you. And so here's the process.
But I think the TM is a great alternative. So let's say that you've done your research and you've developed the great brand. You've got a logo and stuff. You start marketing yourself. You start getting customers. You're a year or two in. But meanwhile, when you first did that and you launched it, put the TM on there.
Absolutely.
That way, when you go to register it, you've got your first use, right? The date of first use, and that's really helpful.
This is something that we used to see a lot more in the 80s and 90s, and the use of the TM because it's not a government mark has not been in vogue as much the last 10 years as it was for a good period of time where it was really strong, like the 80s, 90s, even in the 2000s.
So what is your take on that from the legal side?
Well,
is it better or worse? Does it matter?
Well, so the circle R, the reason why that matters is because it essentially creates the assumption that because it's published in the Federal Register and you've got a federal list of the registered trademarks, that hey, you are presumed to be known everywhere, and so you don't get into these battles about the territorial use of your mark. And so let me give you an example that'll drive that home. If you're just using the TM, if you don't have a registration and you're doing business in Oklahoma under a certain trademark, and somebody else comes up with that same mark later and they're in Maine, okay? There's nothing wrong. There's no likelihood of confusion between those two companies until they touch, until you actually have a territorial overlap between them. In fact, you can have businesses with the same name that subsist forever using those same names. I know something similar happened with 7-Eleven, right, in Oklahoma, where the Oklahoma, am I remembering this right? 7-Eleven's Oklahoma branch was the senior user, but the junior user was bigger and outside of Oklahoma?
Yeah, it was corporate owned versus franchise ownership. They're now all corporately owned.
Right,
but,
right.
7-Eleven was corporately owned everywhere in the country except Oklahoma. The Oklahoma units were all franchise sold to franchise. They've now repurchased them as far as I understand it. So 7-Eleven now is all completely corporate.
But where the you would see some differences in the way that trademark was used because of that issue. Now once you get a federal,
the Oklahoma, when they were owned by individuals instead of corporate, they didn't use the term Slurpee.
Right. Yeah,
they used the term icy versus Slurpee, and so now that all the units are owned by corporate, they've changed all of that packaging and all this because of the use of the terms.
They that's a trademark.
Right.
And so the Oklahoma 7-Elevens had the right to use 7-Eleven because of this legal issue, but they didn't have the right to use Slurpee.
Right.
Okay. So it's really funny, and it's an interesting decision to allow that to kind of continue for as long as it did.
Ultimately, in all of these conversations, when you're the owner of the registration, the trademark, et cetera, you can negotiate anything you want with anyone, whether it is
permission or license,
complete permission, or conditional permission, or absolutely never.
Right.
You're on notice, so cease and desist. Right, we don't want to allow this.
Yeah. But the reason why you get the registration is to avoid the issue where where somebody in Maine doesn't know about you and they're kind of excused for their infringement. And so that's the reason you do it. It's not inexpensive. I mean, expensive is relative, obviously, to somebody's means, but at the same time,
what were you saying, like $2,500 or so? It's the starting $25,000 to $5,000.
It's not a super expensive piece of intellectual property to own, and if that brand matters, then the registration is an easy step. Now
here's the accountant take. You can put that on your balance sheet.
Right.
But I would also say for the marketing take is if you built up enough brand equity, you're generating sales and you've built audience, you can then afford to pay for the protections. When it's a startup and when it's brand new, often the cost is an issue.
I wanted to clarify the TM. Real quick, do you recommend that people do the TM? Because like Kyle was saying, it's not in vogue. But is it if it goes to I'm going to register it a year later, does that matter? If
you're using it as a trademark and it is not registered, I would recommend putting the TM on the mark because you are calling that out as a trademark. And here's the other piece. If let's say that for whatever reason your mark is rejected. Okay, so you go to the trademark office and your mark is rejected. One common reason is because maybe your mark is too descriptive of what you do. Well, one piece of proof that you can use to overcome that, maybe not today, but maybe in a few years, is I have been using this trademark out in public, pushing it along with my product for an extended period of time, and it has acquired distinctiveness, and that's the legal phrase for it. And so maybe my mark was pretty common or pretty descriptive before, and the government said, no, I'm not going to register it. But I can show 5-8 years of continual use, and I can show that to the trademark office, file for my registration again, and they see it in 1999 or in 2010 with the TM by it. And you say, nobody's challenged this for 10 years. I'm not aware of anybody that's done this for 10 years. My market knows what this means now. They know that this is me and not just a generic person with, Oklahoma City Beer Co., right? That would be a good example of one that maybe you couldn't register it on day one. But after 10 years and everybody knows, okay, Oklahoma City Beer Co., I know what that is, then maybe you're entitled to registration because now people associate it with a specific entity. So that's why you want to use the TM, is you want to show that you're holding that out as your trademark.
Can we expand off name and logo? Because in marketing, especially right now in 2022, the branding elements have expanded beyond brand and logo into color schemes, into audio and visual and video because of animated logos, even specific movements that some people are protecting and some people are incorporating into their marketing because it's making a better connection for their audience. How much of that and how do you protect each of those elements as a whole?
Well, I think that one important thing to understand is that you have the marketing side of this question, which is how do you present yourself, right? And then you also have your designation of origin side, which is what trademark is really concerned with. And if your branding and your marketing with the colors and the design elements, if those are so strong as to rise to the level of designating, hey, this doesn't mean, this isn't just a slick way of designing it. This means it's Ross's widget, right? Then that designation of origin is trade dress, which just like a common law trademark that gets powerful enough and you can go sue somebody for copying it. If somebody tries to make their product look like mine, even if they use a different name, right, then I can sue them for trade dress infringement. Because they're trying to make their widget look like Ross's widget. That goes both ways. And it's important to remember, both for someone who is trying to create a strong brand impression using the way that they're colored and the way that they're designed, but also it's a warning against the temptation to incorporate pleasing elements of competitors' products into their own products, right? Yeah. If they think, hey, this color is meaningful. I'll give you one example from an industry I know a lot about, which is kind of underground construction equipment. So we're talking about trenchers and drills.
I thought he was going to say underground bands.
No. much less exciting than that, but yet nonetheless important. Trenchers and drills, where you have, just a few players in this industry and they have very specific colors associated with their products, where if you see a red trencher, that's Toro. Right. Or if you see yellow one, that's Vermeer.
Or there's John Deere green and there's Harley Davidson black and orange.
That's exactly right. And so if someone were to come out with a red lawnmower, now of course you can't stop everybody from having a red lawnmower, but Toro's brand is very strongly associated with red. And so you want to make sure that you're doing what you can as a new lawnmower manufacturer to distinguish your trade dress so that people don't look at your thing and think that's a new Toro. Because if you do that,
you're inviting trouble.
Yeah, exactly. And your goal, if you're really, an honest business person, your goal should be to draw those distinctions as sharply as you can anyway.
Right where we started the conversation. Right back to starting the conversation about differentiation.
Right. Yes. It's all about
so it's good for marketing and it's good for legal.
Yeah, it is.
100%.
We're all friends here. And it's good for the balance sheet, really, because people don't always, sometimes your CPA might say expense that, and that's fine. But you want to keep all the things that you do to protect your brand in a bucket, because at the end of the day, that's your asset that you're building.
And it's ultimately professionalism. And by providing protections and doing your due diligence and all this other work, it allows you the freedom then to go to market as hard as possible, to spend what you need to do and try to establish your audience, try to establish a base and create repeatable business.
Yes.
You can invest in it when you feel confident that it is protected as well as it can be. Right.
Oh, and just to clarify on your trade dress, in the lunch, you were saying that you would do two different applications. It's still a trademark application for the sound component of it. So different from your first mark.
To be clear, a lot of times these things aren't registrable.
Okay.
That's different than being protectable. So, filing a registration in the U.S. government versus I have protection over this trademark sound, if we're talking about the Dolby sound, the deep note, or if we're talking about trade dress and the way that something looks, some of those things may not technically be registrable but they are protectable as trademarks and designations of origin, differentiators in the marketplace.
So talk to your lawyer.
Yes. It's a convoluted question, but our concepts. So anyway.
But ultimately,
it's all good.
It's important, and
important.
It is in the process itself of developing and managing, running a successful business.
Yeah.
Yep.
I agree. Awesome. Well, yay. This team is a tie. Good job. Thanks so much, Ross. Thanks, Kyle. You guys have a good one.
Certainly.
My pleasure.